So I felt that the role of the High Commissioner had to be to work on the ground, to start working on implementation of norms and standards, and avoid the temptation to just continue the debate about refining existing norms that were totally abstract and meant nothing in the lives of a lot of people on Earth.
You wanted to talk about the work of LEAF, and perhaps we can lead into that by the address that you gave to the Human Rights Commission in June in Geneva regarding a study that was commissioned on women's rights. And it underscored the persistence of laws and of customs that make women second-class citizens and then consequently expose them to undeterred and unpunished violence and inequality, laws that restrict women's freedom of movement, that restrict their property and inheritance, practices like male guardianship that put women at risk of being subjected to abuse and to violence and oppression inside their homes and outside of their homes. And when you look at that sort of laws versus customs, how do you interpret the work of LEAF and the need to keep in mind, organizations across the world that are trying to promote those changes?
Well, I have to say, this was probably the biggest shock to me when I entered this world of human rights work internationally. Coming from Canada, I was very conscious that the drive for the pursuit of equality in this country had really started with the pursuit of gender equality, and LEAF was very instrumental on that. It's through gender equality that other forms of, that other equality seekers could come forward. When I arrived on the international scene, it was exactly the opposite. Gender equality was at the back of the bus in many, many ways. In fact, I'm not a conspiracy theorist, but if I was, there is no other form of discrimination that is as universal and as universally enforced as gender discrimination. None. And I think there's no hierarchy of suffering, so I don't want to diminish the enormous work that has to be done in the pursuit of equality for other distinctive groups. I think persons with disabilities, there are lots of groups, discrimination on the basis of sexual orientation or identity, you can't even talk about it in the United Nations. But in terms of the number of people affected worldwide, I think gender equality is still very, very far over the horizon, and the resistance is absolutely stunning. And as I said, it was a very big surprise to me coming from an environment in which women had used the law very effectively to advance their own interest, and through that, to advance the interest of so many other equality seekers. For those of you who know some of these mechanisms, the Committee on the Elimination of Discrimination Against Women, it's called CEDAW in the United Nations, was, to my great surprise, the only human rights-based committee that was not linked to the Office of the High Commissioner for Human Rights. It sat in New York. It was supported in the United Nations by the Division for the Advancement of Women, but it was, I thought, very deliberately de-linked from a rights-based approach, from a human rights agenda. It was seen as a kind of aspirational, social, economic program for the advancement of women. We had to bring the rhetoric and the reality of rights and legal empowerment to women, to bring that where it belongs, in my view, which is at this very center of the protection and promotion of human rights. That battle was an enormous battle, which we succeeded in accomplishing. And the second step was to try to persuade the Human Rights Council to have a special rapporteur or to take an initiative on worldwide discriminatory laws. Again, the resistance of member states was very surprising. And we're not even talking now, we're talking discriminatory laws. We're not even talking of attacking the much more invidious cultural or religious practices that then or have to be tackled at the same time. We're just talking about explicit discriminatory provisions in the law, in laws of property and inheritance, in all battles that in this country we have fought and won in the past 30, 40 years. And where I think that the protection of the law and legal empowerment is absolutely critical to the pursuit of equality for women.
You've also said that that kind of legal framework helps to protect women, to ensure their rights, to combat violence against them. Can you give me an example of what further framework you'd like to see, not particularly in Canada, but that you would like to see implemented in some of those hotspots you've mentioned?
Well, I think the law offers us a vehicle, and I think there are disagreements about that. There are many human rights advocates who don't believe that the pursuit of equality through the law is as effective as pursuing it in a more kind of rough political environment. I think that Canadian history, particularly through the work of LEAF, has demonstrated how important it is first to have a protective legal environment, and that's why I think the constitutional guarantees, in particular, are the highest form of legal protection. So I think in this country, if we go back to the major developments, we go back to the Charter. So it's constitutional protection, empowerment of women. I think the Court Challenges program has been enormously instrumental in allowing women to use the law to advance the agenda. And I think the legal environment allows us to speak in a rational way about issues that are much more difficult to debate as a society and to tackle outside a legal environment. I think sexual violence and domestic violence, a very good example.
Yep.
I think the legal reforms that took place in this country, some of which somewhat counterintuitive, by abandoning the offense of rape as such and talking about sexual assault, that's right, identifying sexual assault as a form of violence. And I think all of this has permitted, all at the same time, a social debate, so leading to legal protection, but at the same time, putting that debate, I think, in a public forum, in a manner where the debate could be tackled in a kind of logical, rational, respectful way, which is not always the case when it's left just to a sort of political, public tug of war. So that's why I think I think in the field of sexual violence, using the law as the point of entry is absolutely critical.
The avenue for discourse.
Yeah. Now, unfortunately, it's not enough when you work internationally in an environment in which there is no real legal infrastructure to speak of. In the Democratic Republic of Congo, I'm sure you're aware, the extent of sexual violence related to conflict is of a level of brutality that is very difficult to describe or to imagine, and of an order of magnitude that is absolutely astonishing. It's very challenging there, and there I question whether legal reform is likely to allow us to address that problem very directly. I mean, you can change the definition of rape, but at the end of the day, if you have no enforcement, capacity, you have no credible court structures. If with enormous effort you can accompany a victim right through the process to laying charges, to seeing the case, forcing the judicial system to take the case, at the very best, in 1 in a million cases, if you can obtain a conviction, if the person is incarcerated, the odds are that within 2 weeks he will have escaped. I mean, there's nothing in the process that works to offer that protection. Then it becomes much more challenging to develop a proper response to
And
that.
it must have been challenging to keep your spirits up in that kind of scenario as well, because I mean it's such a critical job. But if you feel you can't affect that change, there must have been times where it was just insurmountable. I just have a couple of questions for you because we have about 2 minutes left, Madame. There are, as we mentioned, more than about 100 students here who are looking at their options and probably going to ask you some fabulous questions a little bit.